My name is Halia Stojic, and I work at an organization called the Equal Rights Center. I'm the intake coordinator there. We appreciate you coming out today. I'm going to talk a little bit just about fair housing generally and provide an overview. So some objectives of this conversation today is to help recognize potential housing discrimination that renters may face, to help identify how renters are protected by federal, state, and local fair housing laws, and to identify how to report potential housing discrimination. I've also built in a little bit of time throughout to do some quick questions. So if you could just hold it, any questions you have until those points, that would be great. First, just a little bit about the Equal Rights Center. The Equal Rights Center is a civil rights organization that identifies and seeks to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations in its home community of Greater Washington, D.C. and nationwide. One of the primary investigative tools that we use in order to do this is civil rights testing. As you can see in this video here, we have a white tester who's going to a property to ask about availability of one-bedroom units. And in this case, he's told by the agent that they do have units available and encouraged to submit an application. But we see just 10 minutes later, a black tester going to the property and again inquiring about one-bedroom units and their availability. And in this case, instead of being told by the agent or the leasing agent that they don't have any units available, or that they have units available, he's told that they don't have units available. It's really important for a lot of individuals as they're going through this process, because you oftentimes don't know if you're looking to rent a house or buy a house or an apartment or anything like that. You oftentimes just don't know what other individuals are being told. And in situations like that, it's helpful for us to be able to conduct civil rights testing so we can go in and determine whether different individuals are being provided with different information to bolster an individual's allegations of discrimination. The Fair Housing Act protects individuals nationally from any sort of discrimination in housing. And when we're talking about housing discrimination specifically, this applies to any housing-related transaction. So it covers things like rental and sales, as well as things like lending, insurance, homeowners associations, even transitional housing would be covered under the Fair Housing Act. Now, federally, the Fair Housing Act protects individuals against discrimination on the basis of 7 protected classes. And those are race, color, national origin. And to give a quick example of what this might look like in practice, a number of years ago, our organization had an individual who reached out who was looking to apply for a property in Virginia. And she was added, we believe by mistake, to a group text between the current tenant at the property and the landlord. And in that text message, the landlord stated, "I don't want to rent to her. I think she's African. Give her the wrong address when she tries to come and view the property." Now, this was obviously very distressing to this individual. She herself wasn't African, but regardless, it was still really hurtful for her to have this experience and to be perceived in this way. And we were able to assist her with filing a housing discrimination complaint on the basis of race, color, and national origin, because this landlord was refusing to rent to her and misrepresenting the availability of the unit on the basis of his belief that she was African. You're also protected against discrimination based on familial status in housing, and this refers specifically to families with children under the age of 18. So a landlord can't refuse to rent to you, for instance, because you have a child under the age of 18. Individuals with disabilities also have additional protections. I'm going to talk more about those in just a few minutes. But broadly speaking, a landlord can't discriminate against a tenant on the basis of their disability, and tenants also have the right to make additional requests because of their disability. It's also illegal to discriminate based on religion as well as sex, and sex in this case includes both gender identity and sexual orientation. There are some additional protected classes in Virginia, which means that it's also illegal to discriminate against individuals based on their age or elderliness, so specifically being over the age of 55, as well as sexual orientation and gender identity, which are separately codified under Virginia's fair housing law. Source of funds, which I'll talk a little bit more about in a second as well, but this just refers to any legal source of funds that an individual uses to pay their rent. So this could include things like a housing voucher, if you receive SSDI, anything like that, that would be included, as well as military status. That's a separate protected class. Arlington County has some additional protected classes, which are largely the same as Virginia's, with the exception of protections for marital status, which means discriminating against someone on the basis of whether or not they're married is also illegal in Arlington County specifically. There are a number of prohibited activities under the Fair Housing Act and under local fair housing protections. The first of these is refusal to rent or sell. This is probably the most straightforward. In many cases, a landlord might refuse to rent or sell to someone just on the basis of part of their identity. What we see a lot is, in Virginia specifically, a lot of landlords might refuse to rent to someone because they have a housing voucher. In this case, that would be likely illegal. Just as another example of this, we had an individual in Washington, D.C. who reached out because he had a daughter under the age of 16, and he had applied to rent a unit, and the landlord wrote him a letter back and said, "I'm sorry, I'm not going to rent to you. I don't want to rent to anyone with children under the age of 18 in the household." So in that case, he was illegally denied housing on the basis of his familial status or having a child under the age of 18 in the household. Another prohibited activity is discriminatory terms or conditions. So this would apply to a landlord or other sort of housing provider who is imposing some sort of terms and conditions on an individual based on part of their identity. As an example of this, a landlord might state that they won't allow individuals who use a wheelchair to rent above the first floor of a property, even though that property has an elevator and would be accessible to that individual. We've also had circumstances in which families with children, for instance, might have certain terms imposed on their tenancy. They might be told that there are certain areas in which the children aren't allowed to engage, or if we've had, for instance, a family who reached out a number of months ago who were living at a property and had a number of really negative interactions with other tenants at the property. And this family was repeatedly being issued noise violation notices. They had a young child who was, a couple months old, was still learning, adjusting to being alive, and was making a lot of noise. And they had taken a number of steps to try to address this and make sure that it wasn't bothering their neighbors, but they were still receiving a lot of lease violation notices. And then separately, they had a tenant who lived next door to them who actually entered into their apartment without their consent at one point and was operating, just walking around their apartment. And in that case, the condominium association actually didn't take any steps to penalize this other tenant who had essentially broken into their apartment, but was still issuing them lease violation notices. And in that case, we were able to reach out and explain that this was likely a discriminatory terms and conditions, because they were imposing these lease violations only on families with children and not imposing them on other tenants who were breaking other aspects of the lease. Another example of a prohibited activity is advertising a discriminatory preference. This one is pretty straightforward. What we see a lot in Virginia is that a landlord might post an advertisement that says something like no Section 8, no housing vouchers allowed, stuff like that. That's a very classic example. We also had a landlord a number of months ago who had posted an advertisement which specifically stated that he had a preference for renting to a small family comprised of a husband and a wife and a couple of young children. Now, in this case, this was a very blatant example of discrimination, and we were able to assist the individual with filing a complaint on the basis of her marital status, because she was unfortunately a single mother, as well as familial status, because they wanted, I think it was a small number of young children specifically. So discriminating against families with older children or discriminating against families with multiple children. Misrepresenting availability would be another type of discrimination that we see fairly frequently. That's a great example of when the civil rights testing that I just discussed would come into play. It's oftentimes very hard if you're looking to rent a unit to really know what the availability of a property is. As an example of this, we had a tenant who reached out because she had gone to tour a unit and she liked it, and she disclosed at the end of her tour that she had a housing voucher and wanted to rent the unit using her housing voucher. And at that time, the landlord made what she described as an unpleasant facial expression and said, "Oh, we actually just had a really strong application come through on this property. It's really not worth you applying. I'm happy to show you some other properties in neighborhoods that were much less desirable to the client." And in this case, she didn't have any way of proving what was going on here, but she got a bad feeling about it. She thought that there was something wrong here, that the landlord didn't want to rent to her because of her housing voucher. So she reached out to the Equal Rights Center, and we were able to conduct civil rights testing. So in this case, we were able to essentially have two individuals reach out to the property. Now, one individual was posing as a market rate renter, so somebody who didn't have a housing voucher, and the other was posing as a voucher holder. Now, the voucher holder reached out, and at that point, the voucher holder was told the same thing when they disclosed that they had a voucher. They said, "We have applicants in on the property. It's not worth it. We're happy to show you some units in some other neighborhoods." Just 10 minutes later, when we had the person without the housing voucher reach out, They were told there was no applications in on the unit and strongly encouraged to apply. So in that case, it's really helpful to be able to conduct this testing to sort of bolster these allegations and determine whether someone is being told information about the availability of a unit that might not be entirely truthful based on part of their identity. Finally, we have block busting or steering. I'm not going to get into block busting too much, but steering would refer to essentially any sort of situation in which a landlord, an agent, any sort of housing provider is steering an individual towards, it could be a particular building, a particular neighborhood, even a particular unit within a building. Like in the example I just gave, the individual was, I believe this was in Washington, D.C., she was looking at units in Northwest D.C., and when she revealed that she had a voucher, and when the tester revealed that they had a voucher, the agent in that case kept encouraging them to apply to units in Southeast and Southwest DC in neighborhoods that they weren't interested in and never said they were interested in. But because of his preconceived ideas of what a voucher holder should want and where they should live, he was steering them towards particular neighborhoods. Similarly, we've seen before where a building might have a policy where they have families with children that are, they might have two separate buildings that's part of one property. They might put families with children in all of one building, something like that. That would be another example of steering because you're directing someone to a specific unit, a specific building, something like that based on part of their identity. Some additional prohibited activities include harassment, threats, intimidation, and coercion. That could look like a landlord, for instance, harassing a tenant using some sort of racial slurs, a landlord or maintenance staff refusing to use a tenant's preferred pronouns, stuff like that. That's a little bit more complicated, and I'm not going to touch on that too much today, but if anyone has specific questions, you can always come up and find me afterwards. Inaccessible design. So the Fair Housing Act outlines specific guidance for accessibility at properties that were built after March of 1991 and are multifamily units, which means that if you live at a property that was built after that date, then there are some additional guidelines for accessibility that aren't exhaustive, but are meant to include a minimum level of accessibility for an individual, for instance, who uses a manual wheelchair. So within units and in common areas at a property, it has to have certain sort of requirements for things like door pressure, distance between walls, stuff like that, that would allow an individual who uses a manual wheelchair to navigate through those spaces. If you live at a property that was built after March of 1991 and you don't believe that it is accessible, if you have a disability, you use a wheelchair, something like that, we can potentially come out to the property to determine whether it was built in compliance with these standards. And if not, we might be able to ask that they take steps to bring it into compliance. And then finally, retaliation and just any other conduct which makes unavailable or denies dwellings are also illegal under the Fair Housing Act. I'm going to talk just a little bit about source of funds protections now. In Virginia, it's illegal to discriminate against an individual based on their source of funds, which refers to any sort of legal source of funds that an individual uses to pay their rent in whole or in part. So this would refer to things like housing choice vouchers, any sort of emergency rental assistance, any other rental assistance or rental payment programs, Social Security, unemployment insurance, veteran benefits, disability benefits, alimony, or again, any other legal source of income. Some common examples of source of funds discriminations that we see, the first is just refusal to accept vouchers at a property. So as I shared previously, things like a landlord saying that they won't accept vouchers, that they don't accept Section 8, stuff like that. Another issue that we see is discriminatory minimum income requirements towards voucher holders during the application process. Generally speaking, in Virginia, housing providers can apply income requirements, which means, for instance, that a landlord could say, that you have to make something like 2, 3, we even see 4 times the rent. If you have a housing voucher, a landlord shouldn't be applying this requirement to the total rent, but just to your portion of the rent. So for instance, if you have a voucher and let's say your rent is $2,000 a month, but your voucher covers everything except for $200. So you're only paying $200 out of pocket towards your rent. A landlord could apply a 3-time income requirement to that $200 to require that you make $600 a month, but they couldn't apply that to the $2,000 a month to require that you make $6,000 a month. If your rental portion is $0 a month, then that math still applies, so it would just be 3 times 0. They couldn't require that you make anything. So they couldn't require that you demonstrate that you have 3 times any income. If that is occurring, we would always encourage you to reach out to our organization. We can typically assist with advocacy. So if a landlord is misapplying an income requirement, we can reach out to them, explain that that would be potentially illegal under Virginia law, and ask that they reconsider your application and apply the income requirement correctly. And then finally, yeah, advertising no vouchers accepted, which we've already talked about, so I'm not gonna really focus on that. I wanna talk really quickly just about rights for individuals with disabilities in terms of reasonable accommodations. A reasonable accommodation can generally be understood to be a change in a rule, policy, practice, or service that gives a person with a disability equal opportunity to use and enjoy a dwelling. Some common examples of reasonable accommodations are allowing emotional support animals in a building that has a no pets policy, assigning a reserved accessible parking space. So for instance, if an individual has a mobility disability and they can't walk long distances and they live at a property that has a parking lot, they can request that their landlord reserve a parking space close to the front of their building for them so they have a shorter walk from their parking space into the building. And again, a transfer to a more accessible unit would be another example of a common reasonable accommodation. For instance, we might have an individual with a disability who needs a unit that has more space to allow them to navigate with a wheelchair, or an individual who uses a wheelchair and just wants to be located on the first floor if they're concerned about elevator outages or something like that at their property. Individuals also have the right to request an extension to a housing voucher so they can have more time to find housing if it's related to a part of their disability specifically. For instance, we've had clients who've had very specific needs as a result of their disability and can only live in very limited types of housing. In that case, they might be able to request additional time, or if, for instance, an individual was hospitalized or unable to search for housing during part of their time that their voucher was active, they might be able to request an extension on that basis. Individuals can also request that they change the due date for rent to match when they receive their monthly disability income. For instance, if you live at a property where your rent is due on the 1st of every month, but you don't receive your disability income until the 15th of the month, you could request as a reasonable accommodation that you be allowed to pay your rent on the 15th instead of the 1st. And then one other type of reasonable accommodation could be not considering an individual's criminal conviction if it's directly related to a person's disability. This is a little bit more complicated. I don't want to go into too much detail. If anyone has questions about this, I'm happy to answer them after the presentation. But generally speaking, if an individual has a criminal conviction that was directly related to a disability, they could potentially ask that the landlord consider that or take that into account in not considering the criminal conviction. I also want to touch just very quickly on service animals and assistance animals. Service animals specifically are dogs. I will caveat that a service animal can technically be a miniature horse, but in my many years of doing this, I have never seen that. It's not common. A service animal then is really it's gonna be a dog, and it's a dog that's been trained to provide a specific assistance with a specific task for somebody's disability. So this doesn't mean just that the dog can, sit on command, do stuff like that. This is gonna be a more specific task. It could be something like a guide dog for an individual who has a disability. For instance, if an individual has PTSD, they might have a dog that's been trained to walk circles around them to make sure that other people are giving them space when they're having some sort of episode and they need additional support. So stuff like that. Now, there are two types so we have assistance animals broadly, which covers service animals, as well as emotional support animals. Now, an emotional support animal, unlike a service animal, isn't necessarily an animal that's been trained to perform a specific task. That would be an animal that provides companionship and comfort through its presence. Individuals have the right to both types of animals in housing under the Fair Housing Act. Separately, if you have a service animal specifically, so again, an animal, a dog that's been trained to perform a task, you also have rights outside of housing. This is kind of an overview of what we would provide to individuals kind of trying to figure out where an assistance animal might fall. The first question would be, is this animal a dog? If it's not a dog, if it's any other kind of common pet, if it's like an animal that would commonly be a pet, I do want to be clear that assistance animals are not pets and should not be considered to be pets. But anything like a cat, a bird, a fish, anything like that, that could still be an emotional support animal. So it could still be considered to be an assistance animal, and you would have the right to make a request for that animal in housing. If the animal is a dog, the next question would be, is the dog trained? If the dog isn't trained to perform a specific task, if it's just really important that, you know, your German Shepherd or whatever is able to live with you and provide comfort to you, then that animal wouldn't be a service animal, but it would still be an emotional support animal, and you would still have the right to request that he be able to reside with you in your housing. If the dog is trained, so again, think of something like a guide dog or you know, something, or like a hearing dog for an individual who's hard of hearing who might be trained to alert them when there's someone at the door of their house. That would be a service animal, and the individual would have the right to make a request for that in housing. They also have rights for service animals in terms of businesses and bringing them into places of public accommodations. I don't have a lot of knowledge about that, but we're just putting this up here to distinguish that even if you don't have a right to bring an animal into certain places, you might still have a right to have that animal with you in your housing. There are some requirements for considering assistance animals. So a housing provider can't apply a no pet policy to assistance animals. Like I said earlier, an assistance animal isn't a pet specifically, so any sort of pet policy at a property likely shouldn't be applied to them. So even if a landlord says we don't allow any animals, you still have the right to request that your assistance animal be allowed to live with you. Housing providers also can't charge a pet fee for any assistance animals. I know these can be really extreme. We see a lot of properties that, for instance, might require something like a $500 pet deposit, as well as $50 a month in pet rent, which can be a huge financial burden on individuals. If your animal is an assistance animal, they shouldn't be applying any of that pet rent or that pet fee. They also can't charge any sort of additional deposit or collect any other fees to guard against potential property damage. So if you've submitted a request for an emotional support animal or a service animal to reside with you and your landlord says, yeah, that's fine, we'll approve it, we'll even waive the pet rent, but you still have to, you know, put down $2,000 in case your dog damages the carpet, that would be likely illegal. So generally speaking, you know, we encourage people who are making any sort of request to make it in writing, and I'm just gonna flag that now. It's always good to have a written record of anything you're requesting from a landlord. I'm gonna move on just to the last section of the presentation, which is reporting housing discrimination. If you believe you've experienced possible housing discrimination, we always highly recommend that you document your experience, taking down notes about the date and the time, any individual you spoke with, their name, their title, you know, anything you know about that. Always jot down a summary of what happened, any sort of notes about what you discussed, if they made any sort of promises, stuff like that. And then, of course, keeping copies of anything that you submitted in writing. Anyone who believes they've experienced housing discrimination has the right to file a housing discrimination complaint. You can do so at HUD or the Virginia Fair Housing Office. We also strongly encourage you to reach out to us at the Equal Rights Center. We might be able to essentially represent you and go through the administrative complaint process with you if that's something that you're interested in, and we can also assist through direct advocacy during that process. Our services broadly are largely focused on advocacy with a housing provider to address possible discrimination. So as I shared earlier, if, for instance, you have a housing voucher and you've applied for a property and a landlord said, I'm just not gonna rent to you, or they've said, yeah, we'll accept your voucher, you know, we'll rent to you, but you still have to make 3 times the total rent, so you have to make $9,000 a month to qualify. Situations like that, we can reach out on your behalf to explain protections, explain the laws in this area, and request that your application be reconsidered or that it be considered if you weren't given the opportunity to apply. We can also assist individuals with submitting reasonable accommodation or modification requests to housing providers. I didn't really get into reasonable modifications right now, but as an accommodation, a reasonable accommodation would be a change to a policy or a procedure. A modification would refer to a change to a physical structure. For instance, if you have a disability and you need to install a ramp at a property, you have the right to make that request of your housing provider as well. I would just make sure it's transparent upfront that if you are making a request for a physical change, generally speaking, the individual making the request is responsible for any costs associated with it. So if, for instance, you move into a house and you want to install a ramp or something like grab bars, you would be responsible for the cost of that installation. And if the modification that you make, those physical changes, would negatively impact the next tenant's use and enjoyment of the dwelling, you could also potentially be required to pay to revert the unit to the way it was before you moved in when you vacate the unit. If you're making a request for a modification to a common area, so for instance, you want to install like a ramp in a common area of an apartment complex, you would still be required to pay for the initial installation, generally speaking, but then the property would be responsible for any sort of upkeep. And the Equal Rights Center can also assist individuals with submitting housing discrimination complaints to the Virginia Fair Housing Office or HUD. Like I said, we can serve as an individual's non-legal representative or advocate throughout that. We can also conduct civil rights testing, as we've spoken about today. If you are looking to apply to any properties especially, or looking to purchase a property, and you believe that the information you're being given is incorrect or different than what other people might be being given based on part of your identity. So if you believe you're experiencing any sort of discrimination in that process, you can always reach out to us and we might be able to conduct some civil rights testing. And we can also conduct accessibility site surveys. So this was what I was touching on a little bit earlier. But if you live in a multifamily property that was built after March of 1991, it's required to meet certain accessibility guidelines. For instance, we have a number of individuals who will reach out to us because something like the doors of their property are very, very heavy. And if their property was built after March of 1991, we can generally come out, measure door pressure, stuff like that, and to ensure that that's in compliance with the guidelines under the Fair Housing Act. To file a complaint with the Equal Rights Center, you can give us a call at this number, as well as send us an email. That's also my direct number. I'll be over there if anyone wants to talk to me, and I'm happy to give out some business cards as well. But generally speaking, we encourage you to reach out if you have any questions about any of this. And I did build in a little bit of time for questions if anyone has any. I'm happy to answer them now.